Mr. Tony Gerrans from, well, he's going to talk to us about animal law internationally.
All right, thank you, Wes, and good afternoon, everyone. My name is Tony Gerrans. I'm the executive head of Humane Society International, which is an animal protection organization that operates around the globe. But I'm really here today to talk to you based on the experience I had studying animal law overseas. I was fortunate enough to be accepted into a Masters of Animal Law program, which was put together by the Animal Legal Defense Fund in the US and the Center for Animal Law Studies. That's a very unique program. There's only one full-time course like it in the world at the moment, and I've just come back having spent 13 months doing that. So I thought it would be interesting to share some of the salient lessons from what I've learned there and how it might affect the situation for animal protection in South Africa going forward. It's a little bit odd that we should even have to critique whether the law works for animals or not. You know, we would all like that this is the way it works. But unfortunately, that's not the case. Law is a technical discipline. It has its origins in all sorts of different disciplines, such as philosophy and religion and the like. And so we find that the protection for animals really varies significantly from context to context and from country to country. And in many instances, the law is not actually helpful for protecting animals at all. It can be, it can create all sorts of impressions that there is in fact de facto protection, but the protections are very light. So when I set out to do these studies, my friend said, "You're mad, you've chosen the only group of customers who are never going to pay you." And then, they're right. And then when I got there to do the course, and I saw this poster, I realized actually they're wrong, because animal lawyers are the only people who can honestly say that all of their clients are innocent. And you know, I think that's an important part about what this whole discipline is. We are really dealing with a very asymmetric situation. If you look at the animal kingdom, the first problem with animal law is that we have a body of law around the world that works for people, for humans, and we've somehow decided that we are actually separate from nature, and that we can have this discipline called animal law that must encompass the entire rest of all of these different species. And you can see here, here's the column for vertebrate, and in the center here the column for mammals. And if you even look in the category of males, I mean, how can we think that we need to have the same type of regulation with regards to animals like chickens and dolphins and elephants, much less what are we going to do with things like starfish or sharks and so on. So it's a bit of an arrogant assumption in the beginning to say we can have one body of law to manage people and one body of law to manage animals, when in fact animals have vastly different needs depending on what type of animal they are. I mean, the way we've categorized animals between wild animals and companion animals, between animals that are used for our profit or not, so they have different status, or whether animals were bred specifically for research or captured from the wild, all of those things have an impact on how the law treats the animals. So it's a really complicated field, and unfortunately in the past, most of those distinctions have worked against animals. It hasn't really worked to improve their circumstances at all. The first problem that we have with law as an institution for animals is that by and large it treats animals as property. So in law you're either a subject of law and the law recognizes you then, or you're an object. So you can be a beautiful white wolf like that, or you can be a chair. For the most part, up until fairly recently, you were going to get the same treatment in law. So that meant for a companion animal, if your animal was hurt or damaged or killed, the remedy in law, other than a very narrow set of anti-cruelty provisions, which I'll talk about now, was really just for the financial value of that animal. There was no recognition given to the emotional value or to the suffering that that animal might have had. So fortunately, this is changing, but we'll see it echoing through a lot of the law that we've got, especially in South Africa, that this question about whether an animal is a legal person or a legal object is still a major impediment towards getting them proper protection. The second problem is access to the law. Jaco spoke about this extensively, so I'm not going to talk about it very much, other than to say there's not only criminal law remedies that you can use for animals. There's a whole range of other types of law, for example, companies law, environmental law, competitors law, advertising law. All of those types of law can also provide protection for animals, and if we're creative, we can use some of that law to improve the situation for animals where the animal-specific criminal legislation doesn't work. But I'll come back to that a little bit more at the end. One of the nasty tricks that legislators use to create the semblance of real protection for animals is, amazingly enough, is in the definition of animal. So the animal protection legislation in the US, for example, there are 50 different definitions for animals across the 50 different states. And then there's a 51st definition for animals, which is the federal law, which applies nationally. It's called the Animal Welfare Act. And that's the definition of animal at the top there, and it's worth reading if you can bear with the legalese for a moment. It says, the term animal means any live or dead dog, cat, monkey, guinea pig, hamster, rabbit, or any such other warm-blooded animal. And then it excludes 3 categories: birds, rats, and mice, bred for use in research. And it excludes other farm animals, such as, but not limited to, livestock, poultry, or animals used or intended for food or fiber. So what they've done there is they've said, we're going to create a set of protections for animals in the US, federal protections. It sounds amazing, but we're going to exclude certain categories where it's not convenient to offer these protections. So mice, rats, and birds. 90% of animals used in testing in America are rats, mice, or birds bred for research, so they fall in that exemption. They're not treated as animals, bizarrely, and therefore they don't actually qualify for any of the protections that follow in the Act. And then the same there with farmed animals. So the animal category, that other than maybe wild-caught fish or farmed fish, the category of animals where the most suffering is happening are excluded entirely from the protection just by virtue of that little clause. So the South African Act, the same section of the South African Act there below, the Animal Protection Act, has got a comparatively good definition. We don't have any of that same type of limitation. We've got all farmed animals in there. So we have a fairly strong starting point to begin. The problem, of course, there is that there's no fish. And most people don't consider fish really to be worthy of moral or legal concern. But the science about fish cognition is really moving very quickly, and I think that's a question we're going to have to deal with at some point, because I think certainly with farmed fish there are significant moral concerns there. The other problem, of course, with the legislation is then you can have all sorts of protections, but very often the legislation is written then to have exemptions from those protections. So Section 2 of the Animals Protection Act in South Africa has 21 different sections that details all the protections, and each one of those sections has 3 or 4 different prohibitions in it. So it's an extensive list of more than 75 different prohibitions of things that you may not do to animals, or that you would be guilty of an offense if you committed those things. The first section there is perhaps the most powerful in a sense, because if you read there, it says, any person who overloads, overdrives, overrides, ill-treats, neglects, infuriates, tortures, or maims, or cruelly beats, kicks, goads, or terrifies any animal is guilty of an offense. Right? There's no conditionality in that. You just have to prove the elements of their crime plus the mental state of the person involved, and you're good to go with a conviction. But the rest of the section has a lot of conditionality built in it. And if you look at the next one, point B, just as an example, it says, any person who confines, chains, tethers, or secures any animal unnecessarily or under such conditions or in such a manner so as to cause that animal unnecessary suffering is guilty of an offense. So you can see what's been done there. The offense is now dependent on the complainant or the state proving that the conduct in question was unnecessary. So here you have a big problem with farmed animals in particular. So the type of things that we heard about earlier, the confinement of cows for in the dairy and veal industries for breeding sows and for battery hens. They all find justification, the people who pursue those industries, in these type of clauses where these become routine husbandry practices and therefore are necessary for profitability or for some other state of necessity. So remember, if you make a complaint, a legal complaint, and you want to secure a conviction, that has to be proved beyond reasonable doubt. So it's a very big onus that falls onto the complainant or the prosecuting authority to be able to make that conviction. So even if we have this wonderful list of prohibited activities, there are some very high boundaries or some high bars that we have to get over to secure those convictions. Never mind the procedural stuff we heard about earlier from Yaku. So where does this come from? I just want to quote very briefly from a 1947 case, and it seems like we're going a long way, but this type of thinking has echoed right through in our law until December 2016. And what was said in this case is that Judge van den Heever stated that the object of the predecessor of the current act, so this was not related to the Animals Protection Act, but that's not really relevant for the point at hand. It says the object of the act was not to elevate animals to legal subjects, and this prohibition is not meant to confer protection on them. The object was plainly to prohibit one legal subject behaving so cruelly to animals that he offends the finer feelings and sensibilities of his fellow human beings. Right? In other words, the animals don't matter in their own right. What matters is offending other people who might be traumatized or otherwise injured by watching the cruelty. And that is the attitude that is pervasive through a lot of animal law worldwide. And it's a big problem because it's got its origins in the way of thinking that we humans are separate from nature and that the animals don't matter. And there's a whole long philosophical train of thought that can be traced right back to Aristotle, talking about this great chain of being and how humans are superior and really animals don't matter. And in some cases, even theorists, philosophers used to argue that they don't even suffer, that they're just instinctual, and what we're seeing when we hurt them is just a natural response. There's no real pain being suffered there. So fortunately, we've turned the corner, and thanks to the wonderful work done by the NSPCA, we've got two changes that are coming out of senior courts in South Africa which have broken this right open. The first one was the case that we heard about earlier, where the NSPCA was found to be legally entitled by virtue of the statute that created the NSPCA to pursue private prosecutions. That was a huge victory in itself, but coming after that, the court went on to say this amazing thing, and it really bears reading out entirely. It says, constitutional values dictate a more caring attitude towards fellow humans, animals, and the environment in general. This obligation is especially pertinent because of our history. Therefore, the rationale behind protecting animal welfare has shifted from merely guarding the moral status of humans to placing intrinsic value on animals as individuals. Right? And then he refers to a previous case, and he says he recognized that animals are worthy of protection not only because of the reflection that this has on human values, but because animals are sentient beings that are capable of suffering and experiencing pain. Okay, it doesn't sound too revolutionary to everyone sitting in this room, but it really is, from a legal point of view, this is a major change in direction. The court then goes on to talk about Section 24, which is our right to a safe and sustainable environment, and they say animal welfare is connected with the constitutional right to have the environment protected through legislative and other means. I mean, that is really very powerful. They're now linking animal welfare to a right in the Constitution. So when everyone lobbied to have animal rights included in the new Constitution and failed with that process, here's the Constitutional Court making that linkage again for us. And they go on to say this integrative approach correctly links the suffering of individual animals to conservation and illustrates the extent to which showing respect and concern for individual animals reinforces broader environmental protection efforts. Animal welfare and animal conservation together reflect two intertwined values. So this is a very exciting development for people who are interested in animal law. It is, in this context, clearly the judge is talking about conservation of wild animals. So there's some work to be done there still. But the NSPCA did a wonderful job with this. And then again, just this last month, they had a success in a matter in the Gauteng High Court, which is the lion bone trade, which I think they're going to talk about a bit later, so I won't go into in too much detail. But the court picked up on that constitutional court judgment and reiterated it in the lion bone judgment. So unfortunately, the trade was not banned entirely, but that wasn't the matter of the litigation. But the quota on lion bones was set aside. But in that process, the court said, our constitutional and legal obligations that arise from Section 24 require the consideration of animal welfare issues. So now we've got two judgments, one from the Constitutional Court and one from the High Court. I think we're in good shape to move forward and look at a whole new legal regime where the legislature is not moving and we can't get changes to the Animal Protection Act. The courts are basically opening the door for us and saying the Constitution and the values implicit in the Constitution are demanding that we get a change to the way the law treats animals. So overseas, these things are also moving very quickly. This is an amazing project that I suggest if you have a few moments, go and have a look at it online. It's called the Non-Human Rights Project. So it's a gentleman called Stephen Wise. He's an attorney. He spent his whole life fighting for animals. And one day he kind of had this revelation that it's not helpful to fight for individual animals and use all of the skills and knowledge he's had protecting this animal from abuse and that one from neglect. He wants a transformative change, and what he's trying to do is move animals from being legal property to being legal subjects, to being legal persons. And that would obviously be a huge, huge change in the legal status of animals. It has all sorts of implications, some of which are very complicated and are maybe impractical. But he started with higher order animals. He's only asking for chimpanzees and elephants. He's had about 13 different court cases. He's got knocked back in 11. But 2 of them are moving forward, and he may at some point get a judge that is receptive to his ideas and grant what he's asking for. He's not working in statute. He's not working in legislation. He's using common law. Common law is the day-to-day interpretation of the law by judges. Our system of law works the same way. And what it means is that a judge can allow the law to evolve to deal with the circumstances in a society. They can't be too ambitious with it, but there is some room for them to interpret the law in ways that is commensurate with things like our new constitution or our values. So I was fortunate enough to meet Steve Wise, and he's very interested in coming to do this work in South Africa because of our constitution. So that's something really exciting that I would suggest go look at the website. It's really inspiring, and this would be a real game changer. Elsewhere, other countries are moving forward with the same question about legal personhood. In India, a court ruled there that corporations, Hindu idols, holy scriptures, rivers have been declared legal entities, and thus in order to protect and promote greater welfare of animals, including avian and aquatic animals, animals are required to be conferred to the status of legal entity, legal person. This animal should be healthy, comfortable, well-nourished, safe, able to express innate behavior without pain, fear, and distress. They're entitled to judgment. So again, there, the Indian court has, I don't know how they're going to do this in practice, but they've made a ruling and said at least in that province in India, all animals are now legal persons, and that means that their rights must be recognized by law. They're not just simply property to be transferred or disposed of at will. And in New Zealand, some of the indigenous New Zealanders were able to negotiate with the government that a river was given legal personhood. So that's a contractual arrangement. It has its origins in an agreement, but what it does mean again, is that that river must be considered in its entirety in any type of legal dispute as a legal person. So a representative, a duly nominated representative, can represent the interests of that river in a court case in the event there's a pollution or overfishing or something like that. So it's not really animals, but what it does show is that courts are opening the doors where the lawmakers won't act, because very often they are deeply vested in commercial and other relationships with the industries that exploit animals. But where the lawmakers won't act, here you have the courts are opening the doors for these type of things. In New York State, probably coming out of a bunch of wealthy people in New York City, they've passed these pet trust acts. So people are leaving money to their pets. You have a problem, you can't leave money to a legal object, so they create a trust for the pet, But for the pet to receive the money from the trust, the pet has to be a legal person. And the courts are enforcing this law. So it creates this dilemma for the law now. In one sense, legally the animal is property, and the other sense, the animal can benefit from a bequeathment or from a will. And this type of thing is the thin end of the wedge that's really going to open up this debate much more. So it doesn't affect a lot of animals, but legally it's very significant. Then, just up the road from where I was studying, there was a neglected horse called, well, I think the horse was called something else, but he got renamed Justice. And the Animal Legal Defense Fund took the abuser or the neglector, Justice is neglector, to court, but sued in the animal's name. Now, again there, normally if you want to go and represent an animal's interests, you have to be an owner or some other form of curator. Here they sued in the animal's name, and the court, even though they weren't successful in the lower court and the high court still has to make the decision, the court didn't throw them out on that issue. So the court is now starting to accept that animals can be victims of crimes in their own right, not simply as our own property. And so in Connecticut, they have this thing called Desmonds Law. It's really nice to see someone signing a thing like that without that schmarmy Trump smile, because he's taking away some protections for animals somewhere. But this one was a good news story. So Desmond was a dog that was abused, and this lady felt very strongly about, she's a professor at the law school in New Haven. She felt very strongly about this, and she lobbied for this law that says when there is a matter of animal cruelty, the court may appoint an attorney or an advocate to represent the animal's interests in that matter. So that starts to say, well, who's going to take care of the animal afterwards? What is the best outcome for the animal? Should the animal be returned? Should the animal not be returned? But it's also part of the process of accepting that animals must be legal persons in law and not simply objects. Then there's a whole lot of scholarly work. This guy, David Faver, has written about animals as living property. So there are problems with moving animals into legal personhood. And the first one is that they don't really, most animals can't be expected to exercise the duties that come from being a legal person. And that is often used as an argument to deny them personhood entirely. And so people like David Faver are working around that and saying, well, we can have an interim category. We don't have to be property. We don't have to be persons. We could be living property. So what we're saying then is that animals are a legal category that enjoy certain types of protection, so certain rights, and particularly immunity rights, so they're protected from all sorts of abuse, and they can therefore have a curator or a guardian sue under their own name, but they are not persons in the same sense that we are, and they don't bear the same responsibilities that they have to or should vote or do military service or do all the other contractual stuff that comes with that. So that's very exciting. Some of these other books on the side are different ideas in the same sort of vein. The one at the bottom, Zoopolis, is a book about treating animals as citizens. So they're saying we already have different categories for people in law, right? If you are a citizen of South Africa, you have many of the same rights as a non-citizen, but you also have additional rights that allow you to do things like vote and maybe have a bank account and so on, whereas immigrants in the country don't have all those rights. And what Wilkim Licker is doing is he's saying we can use that same framework for animals, and certainly higher order animals like elephants and chimpanzees and companion animals can certainly work within that same framework. We really have the tools to do that. Coming back to how things work on the ground in South Africa and our criminal law, because those developments that I've been talking about could take a long time to mature into actual law. There's certain practical things that are happening in other jurisdictions that could really improve the way the law works in South Africa. The first one would obviously be to try and get rid of all of those exemptions that I mentioned at the beginning of the speech, the question about whether the cruelty was necessary or not, and what we heard about earlier, whether the owner had the resources to look after the animal or not. Those type of exemptions are increasingly being taken out of legislation around the world. Also, the question of the penalties, those were the original penalties. Interestingly, the Act, when it was written, allowed whipping of the offender up to a maximum of 6 strokes. And I wonder if that wouldn't be more effective than the fines or the jail, but I think we might have moved beyond that in South Africa. But what they do have in some jurisdictions, in some of the more progressive states, in the US, for example, they have compulsory mental health evaluation and counseling for people who are convicted of crimes against animals. So there, the social services people are brought in order to try and explore the linkages that we heard about earlier between crimes against other vulnerable groups and crimes against animals. There's that question of animal interest representation in the courtroom itself, like Desmonds Law. There are protective orders for spouses and children and the animals. So very often, we heard earlier from Morgaine talking about how often women are also manipulated in an abuse situation by access to the pet or by hurting the pet. And so here you have provisions in the law that are designed to protect those people and make sure the prosecution of the animal can go forward and the vulnerable people are protected. There's always a question of cost, and so some statutes now have specific terms in, they call it a bond or forfeiture. If your animal is impounded and you are being prosecuted for an abuse or neglect situation, you either have to post a bond, bail, for the animal that covers the care and rehabilitation of that animal during your trial, or you run the risk of forfeiting the animal regardless of your conviction or not. So that's quite a progressive thing that's happening in Oregon and Washington states, for example, where there becomes a financial disincentive to go to court to try to defend these things. Because remember, very often it's very difficult to prove the abuse. So people say they'll take their chances and see if the prosecution gets it done. Now they've actually got to put some hand in their pocket and make sure the animal is taken care of in the interim. Post-trial forfeiture, okay, that's an obvious one that which we have operating a bit in our law as well, and bans on post-conviction ownership. So if you're convicted, you're precluded from owning the animals again. Mandatory reporting of animal cruelty. So this is also an idea that is growing a lot of traction. Vets and other professionals in the industry are sometimes now being called on to report to the either animal protection organizations or to the police in some instances, incidents or even suspicion of where there has been abuse. And also to notify social services to pick up those linkages. And then a huge problem is with, I've heard people talk about it here the last 2 days, with hoarding. So where people transition from being well-intentioned rescuers to a low welfare scenario of hoarding animals, that needs to be dealt with expressly in the law, and that is increasingly happening. Those are all things that I think we can possibly learn from, and some of them might have relevance in South Africa. Getting to the end now, there are one or two other things that I just would like to talk about that maybe are not so familiar to people who work in companion animal law. The first one, there were really exciting developments at CITES this year. I don't know if you're following the Convention on the International Trade in Endangered Species. South Africa's, the government's position there was disappointing, to put it politely, but thankfully many of their proposals were rejected, and we saw giraffe moving into a protected status, lots of type of sea life, including mako sharks, the efforts to reduce the protections for rhino, white rhino and elephant were defeated, and so those protections and the restrictions on trade take place. The captive lion breeding trade, unfortunately, we didn't really get our way on that, so there's a lot of work still to be done on that, and also hunting of black rhino went against us. But that was an exciting process, and the reason why I mention that is because it plays into this business about Section 24 in the Constitution about the protection of our animals. So the more resonance we get across different fields with animals, the more likely we are to be able to get proper support from the state for protection of companion animals. Another two things that are worth thinking about, to leave you with this thought, is not all law revolves around the Animals Protection Act. There is a process by which the South African Bureau of Standards prepares and distributes for comments South African national standards. So just this week, the South African National Standard for the Care and Use of Animals in Laboratories and Science came out for its second round of public participation, and also the code which deals with the, animals in stockyards and animals in transport is also out for 5-year review, and there's also some commentary about the labeling of eggs. So the reason why these things are important is because in a well-functioning democracy, the minister responsible for animal protection, which in South Africa is the Minister of Agriculture, which is bizarre, but that is what it is, he would also pass, or she would also pass, depending on the person, pass regulations that dealt with specific matters about how animals should be treated, such as stockyards or transport or use in laboratories. In South Africa, we don't have any of those delegated regulations. So the SABS, usually with industry, but also with input from the animal welfare community and sometimes the public, drafts these national standards, which are non-binding, but they do, with time, start to become the definitive standard. And so it's really important that everyone involved in the field pays attention to these things. And some of them are quite technical, but for example, the one on care of use of animals in laboratory, that involves companion animals. And there's questions in there about how those animals should be treated, whether the animals should be used in schools or not for education. These are important things. And you know, through organizations like RRSA or the Cape Animal Welfare Forum or so on, we really need to get our voice heard in those things, because many of those things are significantly determined by the animal use industries. And so they're not being written in ways that favor the animals. The last one, similar to that, is the Cape Town City is going extremely slowly, but they are apparently amending the animal bylaw. And that bylaw deals with a lot of the day-to-day transactional issues with regards to animals on the ground, especially dogs and horses, cart horses, and so on. It doesn't really deal with farm animals in the city yet, which is something that I think it should be, because that's become an increasing problem. But that bylaw, that draft bylaw, is going to come out for consultation, public consultation. And J.P. Smith told me yesterday, sometimes when these bylaws come out, they get 7 comments, right? So you're going to get the law that the city wants to make if you don't participate. And this one, the Cape Animal Welfare Forum has put a lot of work into it. I think we've got a fairly good revision to the bylaw. The city's not giving everything that we want, but they're giving quite a lot of it. And when it comes out for public participation, it's up to us to move the dial a bit more on the animal side. We should ask for more ambitious things so they end up settling somewhere in the middle. And Rescue Rehab and other organizations, Cape Animal Welfare Forum, can help collaborate this, but it's important that everyone writes in, and even if you make 1 or 2 simple comments, it's very helpful. So compulsory sterilization, licensing, all those type of things are on the table, and I think it's important we all do our best there to show the city that these things matter for us. We heard earlier about the linkages between other crimes and crimes against animals. This is something that I personally believe should be in all of our messaging all the time, right? We believe that animals are valuable in their own right, but not everyone believes that. So in order to make sure that we don't end up in a situation where we're constantly criticized saying, why are you dealing with animals when there's so many needy people in South Africa, we should be framing our messaging and saying these are really 2 branches off the same route. And if we don't do that actively, we run the risk of becoming politically and socially irrelevant. And I saw a lot of the students who were in my class came from countries in South America and so on. They said that was the major mistake they made with trying to develop animal protection, animal law. They didn't link it directly to human interests. They made it an abstract issue about protecting animals, and it became an us or them issue. And we really need to avoid that in South Africa. It's a real danger. And then that, of course, is the Constitutional Court. I think I mentioned earlier, they really are on our side. I don't know how long that will last for. Edwin Cameron has resigned last month, and I think he was the major driver of a lot of those judgments that came through. But the judgments the NSPCA have got so far are tremendous. They've really opened the door for us, and I think we need to support them in their endeavors with that. And we need to make sure that we strike while the iron's hot, while the court is supportive of these things. The last point I want to make before I close is that law can also be a negative force, right? There are a lot of organizations around the world who defend the abuse they're inflicting on animals because they are compliant with the law. The Animal Welfare Act that I mentioned in America is a prime example of that. There are zoos and farms and laboratories and so on, and anytime anyone criticizes obvious abuse of the animals, they say we're compliant with the Animal Welfare Act, and they are. So bad law can really hold us back. It's not a question of the law being neutral and not offering us protection. Bad law can be a real impediment to getting proper standards. And I think South Africa has a volatile legal environment. It's up to us to take advantage of that to move it forward. This is a rescue of chickens. It's an open rescue that happened in Petaluma in California, 500 volunteers arrived there to break the law in a non-violent way to rescue chickens, right? And the point about what they're doing there is the publicity, right? It's not necessarily, I don't want to get into the business about whether the law breaking is a good thing or not, but what, we can talk about that later, got lots of thoughts. But 500 people, and 10,000 people marched in London for the animal rights march. It's not an animal welfare march, it's animal rights. 10,000 people. So I think to start here, we've got a really good core of people, but we really need to make our voices heard. Animal protection needs to become a political issue. In closing, I like this cartoon. It really sort of summarizes a little bit about where we are with animal law. It says, "We have a long way to go," sighed the boy. "Yes, but look how far we've come," said the horse. Thanks very much.
All right, Tony says he's got time for a good question, not a difficult one. So we'll take one question. Who's feeling brave? Who's got something legal? No, attorneys don't talk to each other. They just send letters. No questions. There is no questions.